This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
My lords, we are constrained to move this, my lords, in the most peculiar circumstances. A police officer, my lords, is on patrolling duty in the hours of 29th of July and 30th. 28th and 29th. Early hours of 29th. He gets at 3:15 a.m. a secret information that in a particular house of a particular person, my lords, there is stashing of cash and of some material, and therefore there is urgency at 3:15 a.m. that the premises be opened and investigation commence. He informs his superior. Superior says yes, do it. Makes a general diary entry at the police station. He doesn't go, but it's done over telephonically. And with the police force, he goes knocking on the house of the present petitioner's brother-in-law. The house is not opened. They use force. They enter. They ask the persons who are there. There are some women. There is the brother-in-law, that we have come. We have information. We want to search your house. All that is done in the early morning, and in the search, they find there are gold bars and cash items which are present there. Some of those items are in boxes. Some are in almirahs. Those almirahs are broken open, and then they are seized.
No, items are found, if I am not wrong, from cupboard.
Yes. Almirah, my lords, are where they say the cash, etc. is all stashed. And then there are gold bars also. They call some jeweler to verify whether the gold bars are authentic, etc. And thereafter, my lords, the person, that's the brother-in-law, he is taken to the police station.
After 26 hours.
And he goes to the police station, my lords. And at the police station, his statement is recorded, in which it is a confessional statement which is recorded. All this, my lords, is from the record. Thereafter, my lords, at the police station, an FIR is registered at the police station. All this till the investigation of, till the registration of FIR as investigation has already taken place, which is entry, search and seizure, and arrest. All three acts have taken place before the registration of an FIR. Now, in the confessional statement, and what comes to that, sorry,
I'm interrupting you.
No,
Under section 106
yes, madam.
BNSS.
Yes.
Is there any bar if there is no FIR is not subsisting?
No, my lords, not a bar, but in the peculiarity.
6.1 doesn't impose any bar, explicit bar.
No bar, my lords, but in the peculiarity of how it is. Suppose there is a cognizable offense taking place, in the sense why there is no bar, I may explain, my lords. A murder is taking place and an accused runs into a particular house and hides himself. Police officer is there, he has seen that particular act being taken. He then has to open the premises and apprehend that particular accused persons. So an offense has taken place. Here the offense is taking place before, from a source information that this particular police officer is supposed to have. Who has told him? We don't know. And please, when I take your lordships to the FIR, I'm sure your lordships have already gone through it. The FIR is so detailed as far as what was the allegation. There was illegal sand mining, it was happening. Now, there's one preliminary point. Possession of currency notes in my house and gold is not an offense under the IPC. It is only, if at all, an offense under the Income Tax Act. Only the income tax authorities have jurisdiction as far as cash is concerned in a particular house. Then it is upon me to explain to the income tax. And that is why, my lords, your lordships may bear in mind that income tax offences are not as scheduled offences as far as PMLA is also concerned. So if I am found in possession of cash which is beyond my known sources, not in the prevention of corruption sense, but beyond, as a private person, I have cash in my house, my lords, then it is no offense for the police to start investigating that we have found so much
But whether we keep cash in cupboard,
yes, my lords, for safety.
it may not come under the purview of, as you are saying.
Yes, my lords.
It does not come under the purview of BNS. Rather,
my
it
lord.
comes under the purview of Income Tax Act.
Lordship, please.
But whether a prudent citizen
Yes.
or a man of ordinary prudence keeps those items in the cupboard.
Yes, my lord, I'll indicate. There are certain business transactions, my lords, in India, which are also primarily based, my lords, on cash transactions. Selling of country-made liquor, my lords, is based on cash transactions, where people come and buy, my lords, for small amounts of money. Those are the things. Here also, as far as mining is concerned, it is there. Now, please, when your lordship sees the FR in the facts of this case, that at 3:15, they could not wait. What is the source information, my lords? Nobody knows about the source information, who this information has come from, that this particular person. And I am not even in that house. Please bear in mind that part, my lords. It is not my house. I'm not even in that house. I'm not even present there.
You have left country on 23rd of May. As you have stated.
Yes, my lord. So I have gone, my lords, on 23rd May. This is happening on 29th of July. And therefore, they go to my brother-in-law.
Why you have left country?
I've gone, my lords, to roam around. It's a, my lords, to
Roam around.
roam around, my lords. It's a,
So you have left the country on 23rd of May and this seizure was made.
But they-
Some valuables are, not some, huge valuables
all
are
right, my
found.
lords. Yes.
And you are saying that this court will exercise extraordinary jurisdiction, which is not a routine procedure
No, I'm-
as contemplated in Niharika infrastructure.
Yes, my lords. I am praying for your lordship's consideration.
And the investigation is at the nation stage.
Lord, the section that has been invoked, section invoked is 111, which is organized crime
Please come to page 127
of the paper book.
of
my
the
lords.
writ petition.
Yes. So, my lords, please mark, my lords, as far as quashing is concerned, your lordships will see the ingredients of the offences. The
Please
offense,
come to page 127.
127 is in second one. Yes, my lords.
Please place remarks column
Remarks. my
or
lords.
the
Yes.
narration under the heading remarks.
Yes, my lords. The search and seizure operation was initiated in the early hours of 29/7/26 on the basis of credible source information. The commencement of search was initially delayed to the non-cooperation of the occupants of the house. Upon completion of the necessary legal formalities, the search and seizure proceedings commenced at 5:52 hours on 29/7/26 in the presence of witnesses named herein. The property is two-floor building with 5 small rooms on each floor. As the search progressed and substantial quantities of Indian currency and yellow-colored metallic bars were discovered, additional police officers and force was requisitioned and subsequently joined the operation to ensure the safe, systematic and transparent conduct of proceedings. Now, my lords, the persons are mentioned therein.
Yes, yes.
During the search, the seized properties comprising of Indian currency and yellow-colored metallic bars were, there's a stamp, were
Yellow color metallic bars were
recovered principally from two locations within the house, namely cupboards situated on the ground floor and cupboards situated from on the first floor. On the ground floor, one cupboard described under Exhibit V was found containing 25 bags filled with Indian currency note. Each bag was opened individually in the presence of the witnesses. In each bag, handwritten slip indicating amount was found. All such slips have been seized as Exhibit 59. Currency was removed, sorted denomination wise and counted. Considering the exceptionally large volume of currency recovered, additional currency counting machines were arranged through a liaison.
What more is necessary at this
But
stage?
it's not me. My lords, kindly bear in mind, my lords.
But the suspect comes to
He is arrested.
Suspect comes to be true.
He is arrested.
The suspected, the officer, the concerned police official who suspected and entered into the premises in question and recovered, and this appears to be true. True.
No, it appears to be true, my lords, based only on my confession. They have no idea how I've got this. Now, please read that part of the FIR where they say that this is all from the person, what he has indicated. This is the seizure part which your lordships were pleased to read, my lords. Please see the FIR.
No, since the rule, as I follow, having seen the relevant judgments, that if I find that there is a prima facie ingredients are found for investigation, it's not a routine procedure, Mr. Dev.
No.
It's not a routine order which is required to be passed on an application under Article 226 seeking interdiction of High Court in a criminal proceeding.
Lordship,
So
please.
therefore, if these ingredients are there, I'm not at all satisfied with regard to the case.
Please allow me to persuade, my lords. I am on the malefides as far as the beginning of the starting of the investigation is concerned. That at 3:15 a.m. who gave them the information that this is there? Obviously, it is not as what is written in the FIR. Your lordships have to see the FIR. Therein
Let
it
the
is
investigation
indicated.
be proceeded with.
No, please see
And
the
at this
sections.
stage, I will not interfere.
My lords, kindly see the sections that is invoked. It can't be invoked. On that, your lordships will see whether that section is made out for a quashing of an FIR.
Whether the sections have been rightly invoked or not,
Yes.
that is a separate thing. But there are the ingredients which are there. So let the investigation be carried out.
Look,
And if you find that during course of investigation, these sections were not required to be fastened, in that event, you approach the jurisdiction magistrate.
my lords, in the quashing itself, your lordships have to see, my lords, with respect. Those are the judgments. Whether suppose I am today accused of cheating, and the cases of cheating are
And
there.
if you are in custody, apply for make an application, move an application under 483.
It's not me. The person who is in custody is there. That is the.
And the petitioner, he is
Yes.
out of country. Let him move an application under
Let's
483.
kindly allow me just for a moment.
Why this court will entertain this Article 226 application
Because this
seeking
section-
quashment of the proceeding?
Please, my lords, lordship may have a look at section 111 for a moment, my lords. The primary allegation against me is under 111 of the new BNS. 111 is adopted from section 15 of UAPA. Please see, now we have UAPA which is incorporated under BNS. Those are the offences of organized crime. Now this organized crime, my lords, requires that certain charge sheets have to be filed for the invocation of section 111, that certain charge sheets have to be filed 6 months before in cases. Now if that criteria is not fulfilled, my lord, there is no way that 111 can be invoked. That is one part. They have invoked cheating. Who have I cheated? There is no complaint. It is the police officer who goes, who recovers. There is extortion, not a complaint. Because we have to have some sort of a semblance of the rule of law as far as not a police officer who is the roaming sheriff, my lords, who goes around entering people's house in early morning 3:15. Kindly see whether those offences.
And it was things were recovered, valuables were recovered.
Yes, my lord, but the
And that not from the almirah of the person.
the law, my
It
lords,
is from cupboard.
Lords, I respectfully submit that law is not about proof of the pudding is not in the eating.
At
Merely
this
because
stage-
I went into
but
it.
at this stage, court is not required to go into
But
the
100
aspect.
your
That
lordship-
will be considered
Because
during
your
trial.
lordships are required to see, my lords, at the stage of quashing whether the ingredients are made out. All judgments on quashing, my lords, from Haji Iqbal, etc., my lord Muhammad Wajid, are on whether ingredients are made out. my lord.
Haji Iqbal, paragraph 14 says attending circumstances.
Yes, my lord, that's
I am
what-
not at all satisfied with the attending
Pending
circumstances.
circumstances is because, my lords, kindly see, this is a crack of dawn operation. They could not have done it any other way. And therefore, the source information, because they don't even have one complainant before them, not one.
With regard to incorporation of section 111, you can approach jurisdiction magistrate.
No, my lords, how can I go, my lords? That's why that's why it is before your lordships as far as quashing is concerned. My lords, all quashing judgments are whether the ingredients from Bhajan Lal.
Paragraph 33.16 of Niharika infrastructure, it has been succinctly decided by the Supreme Court that when there are preliminary ingredients found,
Yes.
this court, while considering writ petition, is not required to find out the veracity of allegations.
Yes.
So therefore, since the investigation is at the nascent stage,
Yes.
so therefore, investigation should be permitted to continue.
Yes.
And if you find that you have a case, then move an application under section 482.
Because I'll explain this by way of analogy.
Yes.
Suppose the FIR said murder, also in it, old 302, now 103, my lords, old 302. And I came before your lordships to argue, my lords, there is no murder that has taken place, my lords. Your lordships court, my lords, under 226 or 482, my lords, would necessarily have to look and ask them that, look, how is this made out? This offense has not taken place. That is precisely what quashing is, my lords.
But that does not appeal to this court in view of the huge valuables which were recovered on 29th and 30th.
Lords, 2 points, my lords. Recovery of valuables, again I reiterate, my lords, and resubmit before your lordships, that is not an offence under any of the provisions of BNS. Not one is an offence. Either I can have as much. They should have informed the income tax authorities. Income tax authorities would have come, and income tax authority would have seized the goods and proceeded in the manner they thought best. But till date, income tax is not there. Their allegation is that I'm indulging in illegal sand mining. Now, illegal sand mining, my lords, is covered under the MMDRA Act. It is a complete code by itself. Not one provision of MMDRA Act has been invoked by them. This is completely overreaching the jurisdiction, my lords, of the police. There is nothing more in it. Please have a look at 111, my lords, if that can be invoked at all. And the sections, no.
The petitioner has left the country.
Well, they went in May, they could not have foreseen. There is no FIR, there is no proceeding against me.
And not only this, this criminal proceeding which has been initiated based on the FIR, which is at page 93, rests on 111. There are other sections, 316, 316, 5, 318.
Yes. Now,
So
please,
let it be investigated upon.
I'm obliged to your lordships that it fell from your lordships. They are relating to offences in 2021. I have a chart with me. I can show to your lordship. Those 6 FIRs that they have mentioned, that we have 6 FIRs against them, relate to an offence has taken place in 2021 according to them. 21, an FIR registered 5 years after that. Obviously, my lords, that is obviously done on the basis. If I can hand over the chart with the summary of those allegations.
This chart is there, page 167.
167, my lords.
Yes. Of your writ petition.
Same chart, my lords, but this is more elaborate.
Come to page 167
Yes, my lords.
of your writ petition.
Yes, my lords. I am at 167.
Yes.
No, this doesn't.
The oldest one is 7 July 2025.
No, I know, but
But all are 23rd of May 2026, 1st of June 26, 19th May 26, 4th of July, then 6th of July.
they don't indicate the date of incident, is what I'm saying. That is why I've handed over this. There's more details.
This is not a case, Mr. Dave, that that the alleged commission of offence took place 5 years back, and this writ petition is criminal prosecution has been initiated based on FIR.
No, my lord.
This seizure was there was a seizure, and this seizure was on 29th of July 2026, and FIR was registered on 30th of July 2026, if I am not wrong.
My FIR is registered on my confessional. 30th July on my confessional statement of the co-accused. It can't be, my lords. That's strictly covered by Agnu Nagesia, where Supreme Court said, my lords, it is barred. You cannot read.
Court is also disturbed because court has to consider the attending circumstances. Rightly, you have pointed out, as it was observed by the Supreme Court in paragraph 14 of Haji Iqbal, that the petitioner is like Indrajit in Ramayana.
Yes.
He is watching the proceedings behind the cloud.
My lords, the paragraph that is falling from your lordships, my lords,
Yes.
I know Haji Iqbal, allow me, my lords, I argued it, so therefore, my lords, I have some nostalgia for that particular.
That is the privilege of this court.
Yes, my lords.
To hear Mr. Dave in this
I'm
matter.
obliged, I'm grateful, my lords. But Haji Iqbal is where it is the malice on part of the investigating agency, then those attending circumstances will be looked at by your lordships. For the first time, my lords, apart from Bhajan Lal, that clause 6 of that at 6, whether there is any malice, my lords, Supreme Court had said, my lords, not to look at, only look at whether offences are made out or not. Now Haji Iqbal opened the door a little, that if it is actuated by malice, then your lordships in 482
But
to
if the
26
petitioner is out of the country, then what order you require?
No, my lords, I am
You are free there.
No, but my lords, this is my
You are
country.
free there, Mr. Dave.
Because I can understand if after the FIR I had fled, then your lordships may shut the door and say, look, Mr. Dave, your client left without on the juice. I'm already away. I am not in India. And then the FIR is registered, my lords. And then, my lords, if I come back,
Come to page 167.
167,
Yes, again, let us come to page
yes,
167.
please see, my lords. Uski copy do na wo chart.
On the date petitioner fled, there is an FIR 150/2026 dated 23rd May
Please
2026.
see that FIR.
Right? Then please serial number 4, 19th May 2026.
My lords, please see this chart, my lords, that I have handed over. It would shock the conscience of this court with respect, I'm saying. So if after 21, merely because there are certain changes that take place, my lords, does not entitle the state
No,
police.
this matter does not relate to the political
It
change.
does, my lords. It is borne out by the
Because
first
the petitioner
FIR.
is not a political person.
My lords, 167, your lordships may see, the first FIR, which is registered on 19/5/26, is relating to an allegation of 4/5/2021. 2021. How does a person know, my lords, that in something that happened in 21, FIR is going to be registered in
No, no, but
2026?
I am not on this 19th May 2026 FIR.
Yes, even the other
I am
one.
on with regard to Mohammed Bazar police station case number this
316,
20 that is dated
23/5. That is also relating to an allegation a year earlier. 1 year earlier, my lords, that the complainant had hired a vehicle for 25,000 per trip, and therefore the cheating case is now levied against him, my lords.
FIR number 267.
267.
Challenge. Page 93.
267 is the present one.
Yes.
267 is the present one, but all the other, which is
There in the present one, there is no issue that the incident relates back to to a date of which is that the alleged incident took place 5 years back.
because there is no there is no date of incident in the present FIR. There is no incident.
Very basis of this initiation of proceeding is the seizure.
My lords, yes, so I'm again laboring, my lords, for your lordship's consideration. For criminal law to kick in, there has to be an offense, is what my submission is, my lords. Here there is no offense. There is a recovery which is not an offense under BNS. Under BNS, it cannot be prosecuted by the police, is my respectful submission. If there is an offense pursuant to which recovery, investigation, etc. takes place, then one can understand, my lords. But here it is the other way around. There is a seizure investigation trying to find an offense. Now please ask them, holding currency notes.
But if we come to section 106, there is no bar.
No,
Let us come to section 106.
But 106 assumes that there is an offense, my lords.
Let us see.
The entire code of criminal procedure. I'm sorry, my lords, I keep referring back because I'm still not as well conversant with BNSS, my lords.
Yes, yes, 106.
And powers to search. Any police
Who
officer.
says so? You are not conversant.
No, I'm with the sections, my lords.
Come to section 106.
Yes, my lords, I'm obliged. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Again, my lords, offense. There is no offense. With respect, my lords, what is the offense? Please see. If there is an offense, that's why I'm saying, my lords, how does criminal law kick in? Your lordships are, I don't have to labor on that part before your lordships, my lords. Their jurisdiction comes when there is an offense. They find something, please inform the income tax. Please ask them to go there. Please ask them to see.
What they will do, this court will not direct at this stage.
But
let the investigation and be carried on, and let it be continued.
But my lords, there is no. Please, now your lordships has the book, my lords. Please have 111 of this BNS. Please have 111.
BNSS.
BNS, my lords. BNS. That's the IPC.
BNS.
Yes.
Oh, organized crime.
Organized crime.
Yes. 111.
Yes, my lords. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber of crimes, trafficking of person, drugs, weapons, illicit good or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute an organized. And please pause here, my lords, for a moment. It talks of a continuing. This is continuing because it's borrowed verbatim from section 15. Now, organized crime means the group of two or more persons who, acting either singly or jointly as a syndicate or gang, indulge in any continuing unlawful activity. Continuing unlawful activity means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment for 3 years or more, undertaken by any person, either singly or jointly, as a member of organized crime syndicate or attempt to commit culpable homicide, organized crime on behalf of such syndicate in respect of which more than one charge sheet has been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense and includes economic offense. Now, please mark this.
This is the definition of continuing unlawful activity.
Yes, my lords. In that, the criteria for invocation is that I should have one charge sheet filed in the previous 10 years on which a court has taken cognizance.
Now, if we go back to section 111 subsection 1,
Yes, my lords.
for my understanding,
Any continuing law,
any continuing unlawful activity including kidnapping,
robbery,
vehicle theft,
yes,
extortion,
yes,
land grabbing,
yes,
contract
Trafficking.
killing, then economic offense.
yes, no doubt,
Yes, then economic offense is also defined separately.
yes. But
Criminal
continuing,
breach of trust, forgery, counterfeiting of currency.
yes, that
Now,
comes,
the criminal breach of trust is one of the sections fastened,
no doubt, my lords.
section 316.
But
So why this court is required to confine to the definition as attributed under section 111?
because
Subsection 1II.
because the offense is of continuing unlawful activity,
Any continuing.
which is organized crime. Organized crime is a continuing unlawful activity. That unlawful activity sub-ingredients are robbery, extortion, etc. But continuing unlawful activity, because it is continuing, is separately defined in Roman 2, by meaning that for it to kick in, necessarily it has to have a charge sheet which is filed in the preceding 10 years on which cognizance is taken. That is a given, my lord. There can't be a quarrel by anyone on this particular proposition.
Including economic offense. Yes.
My lord, so please see this.
So your submission is this continuing unlawful activity includes economic offense.
It
So
does.
therefore, continuing in order to constitute the offense, which is to be termed as continuing unlawful activity,
Yes.
then there is a requirement to satisfy the conditions as stipulated under 111(1) II.
Lordship pleases. Because this is an offense which is separate from those sub-ingredients that are mentioned. I can be prosecuted for robbery separately. I can be prosecuted, my lords, for theft, extortion. That as an individual. But if it has to...
If in a criminal prosecution, there are several sections fastened
Yes, my lord.
or incorporated.
Yes.
Now, out of which, if it is found that one section may not apply in
Yes.
in a given situation,
Yes.
in that event, that liberty is always there to approach the appropriate forum.
Well,
For that, you need not approach the.
I will-
In Article 226, I will grant you leave.
My lords, I will address, my lords, and best to my endeavor show none of the sections apply.
No, that I will not.
None.
I will not treat at this time.
My lords, your lordship,
At the nascent stage.
at this stage itself, my lords, they have to be. Because if there is no other stage available to me. Tomorrow, if they file the charge sheet, my lords, the objection will come. Now,
Because
charge
I am
sheet.
not hearing. It is not a trial going on.
No, not a trial.
Let the investigation be carried out.
I am asking your lordship to see it on the face of it. From the FIR, your lordships have seen, which talks about seizure of two kinds of commodities. One is cash and one is gold. On that particular seizure, my lords, your lordships may see as far as whether any of these offences are made out, my lords. That is all that I am asking your lordships.
Mr. Dave, in that event, I will not. I am not satisfied with regard to passing an interim order. If you pray for, I can direct the parties to exchange pleadings. Otherwise, I have to pass a final order.
No, my lord, then-
Choice is yours.
No, but I bow down, my lords. Of course, I see what is falling from your lordships, my lords. But as far as then, my lords, on a prima facie basis, if I establish this, that I have an arguable case before your lordships, my lords, that I am arguing it, subject to whatever the other side may argue before your lordships today. My revision, which is there also with this, that they are taking steps I can address that part also before your lordships then. This is an arguable case, though it comes across.
But I don't want to mix up your revisional application with this 226 because the parameters are different and the different scrutiny is required to be considered. Should be resorted to. So therefore, I want to decide this 226 application first.
Even assuming your lordships decide this against me, my lords, for a moment I take it that your lordships are not inclined in this. Even then, my lords, my revisional petition, I can show to your lordships the manner in which non-bailable warrants are issued and the proclamation is done by placing reliance on two judgments, one of the Honorable Supreme Court and one of your lordships court, is completely, it doesn't apply itself. On the first date itself, my lords, on the date, there is a non-bailable warrant issued. How is a non-bailable warrant issued, my lords, on the first day itself where the police has made no effort to locate me or find me or done anything apart from that? First day. And the magistrate says that in Dawood Ibrahim's case, my lord, Supreme Court has said that I can issue at the stage of investigation. So therefore, I am issuing. That is the only criteria which is the issuance. And in the second time when it comes from proclamation, he says, I have issued it based on Dawood Ibrahim and therefore I am issuing the proclamation. My lord, surely these, and the Supreme Court and your lordship's court has said, these are matters of serious nature because they attach a criminality to a person, my lords, issuance of a non-bailable warrant. And Dawood Ibrahim was a case where after filing of charge sheet, 167 remand came into play, and on that remand, my lords, it was a question of persons against whom charge sheets had not been filed, whether they could be arrested or they could not be arrested. Now, if your lordships think, I am only praying that as far as the investigation is concerned on the first, if your lordships are not inclined at this stage to interfere with and hear the matter finally on a particular date, but as far as revision is concerned for a person who was not in the house, whose house it is not, and based solely on the confessional statement of the brother-in-law, he has been implicated, and that confessional statement has been set out in extenso in the FIR itself, my lords. It is astounding how a confessional statement can be there in a FIR. Please see the FIR if your lordships have seen it, but please read with me, my lords, that part where he says.
So in that event, let me pass an order in 226 application.
In the writ petition, let the affidavit come, but there is another prayer. All my properties are
Of course, after hearing the learned advocate correspondence.
My lords, there is one as far as seizure of
Because I will not mix up those two matters.
No, I'm not. In the writ, my lords, there is one subsidiary prayer which is there before your lordships, which is there that they are going on attaching all other properties of mine. They have enough material of mine with them, my lords, as is evident from the FIR itself, my lords. It's not some small amount which is there. Are going around attaching for the time being those coercive steps your lordships may consider. If they don't apply, my lords, these sections. Suppose your lordships come to a conclusion on the next date and I'm able to persuade your lordships, my lords, that none of these sections are made out and your lordships agrees with me and asks the state, my lords, this is not an offence under BNS. Seizure of money and gold is not an offence under BNS. Please report to the income tax authority. Then, my lords, all these attachments, my lords.
Yes.
That is the judgment of Supreme Court in Nevada, my lords, that I may place before your lordships. This.
Just see. And my sealing of my house cannot happen on the first day. My house, my para 9 of the para 9 of the
Yes, it starts from page 4.
Page 4.
Nevada judgment.
Yes, my lords. Para page 22, my lords.
Yes, page 22, paragraph
28, my lords. Para 27 is the conclusion. Lordships may have a glance, my lords. I apologize. Having held and elucidated on the power of the criminal court, we find good ground and reason to hold that the expression any property appearing in section 102 of the code would not include immovable property. We would elucidate and explain. The first part of subsection 1 of section 102 of the code relates to the property which may be alleged or suspected to have been stolen. Immovable property certainly cannot be stolen and cannot fall in this part. The second part relates to the property which may be found by a police officer under circumstances which create suspicion of the commission of the offense. We have already referred to the judgments of the Delhi High Court in P.K. Parmar, Swan Sabarwal and Jagdish Chandar, which have elucidated in a restricted and narrow manner defined the requirement for invoking the second part. However, we have come across a decision of this court in Teesta Setalwad on an appeal from the judgment of the Gujarat High Court and had dealt with the situation when an act of freezing the accounts was a sequel to the crime as the crime was detected earlier. The Gujarat High Court took a somewhat contrary view by not interfering and directing defreezing, observing that even if the action of the investigating agency at inception to seize may not be regular, the court cannot be oblivious to the collection of substantial material by the investigating agency which justifies its action under 102 of the code. Further, when the investigation had progressed to a material point, defreezing the bank accounts on the basis of such argument would paralyze the investigation, which would not be in interest of justice. After referring to the factual matrix in Teesta Setalwad, this court observed that the investigating officer was in possession of material pointing out the circumstances that had created suspicion of the commission of an offence, in particular that investigation and therefore exercise of power under 102 would be illegitimate as it was exercised after following the procedure prescribed in 2 and 3 of the same provision. 102 postulates seizure of property. Immovable property cannot in its strict sense be seized through documents of title, etc. relating to immovable property can be seized, taken into custody.
This is a case of defreezing of account.
Sorry.
This is a case of freezing of account.
In our case, my lords.
No. It's a case which you are
Of my lords, freezing of attachment of properties, my lords.
freezing of account.
And immovable.
Account was debit frozen, probably.
Sorry, my lords, it was.
So how does it relate to the present case when on seizure it is found that a huge amount of gold bars, silver and cash were recovered from cupboard?
This para 9, my lords, in my writ petition, para 9 in my writ petition deals with the immovable properties being seized.
No, but it has to be considered based on the facts of the present case.
It can't be.
Immovable property may have a wider connotation, but that does not mean that the freezing of bank account would be related to
Not
the
bank
present facts of the case, where huge amount was gold bars, silvers, and cash were recovered from cupboard.
In that house, my lords, which is falling from your lordships, as a crime scene that can be sealed, my lords. My properties, which I have addressed in paragraph 9 of the writ petition, your lordship.
This matter, the facts of the case, so far this Nevada is concerned, is relating to freezing of account.
And that says you can't attach immovable, you can't seize immovable properties because immovable properties cannot be stolen, immovable properties can't be there. Kindly see para 29 and 33 and 34 specifically. Please see that, my lords. Para 32 specifically, I will not read the others. In case, at page 24. In case and if we allow the police officer to seize immovable property. Please see this. On mere suspicion of the commission of any offence. Sorry.
But it talks about seizure of immovable property, attachment of immovable
Cannot be done.
But how? But in this case, the movable properties and the valuables were recovered.
No, but now they are. That's my prayer in the writ also, my lord. That's why I was pressing for the interim stay since it fell. Your lordships would hear it. In para 9 in my writ, they are attaching my residential house. They have attached my office buildings. All that can't be done in view of the Supreme Court judgment. You can seize whatever you want as far as immovables, because otherwise you will become the police officer, not you, my lord. Sorry, the police officer will become an adjudicator, is what the Supreme Court says. So those properties have to be ousted. A residential building.
No, but the court is focused so far. The present case is concerned with regard to the seizure made on 29/30th.
But that is there. That is against.
But during course of investigation, if such attachments are made, then you have to approach the appropriate forum.
Your lordships is the forum. There is no other forum I can go to.
You can approach the jurisdiction magistrate.
Jurisdiction magistrate has no power. There is nothing before him. This is an administrative. This is an action by the police. Only your lordships' wide powers under Constitution, my lords, under 226 can protect a citizen, my lords, between the guardian between the state action and excesses, my lords, and the citizen. However bad the citizen may be, my lords, but your lordships' powers are operate, my lords, without any looking at what search, seizure, that particular property, assuming, my lords, that's a scene of crime, are seized by them. But can't go on sealing all my immovable property, including my residential premises. Please see my prayer, my lords, in my writ, page 11.
Page 11, para 9.
There are reasons for incorporating section 111. It's an organized crime which is going on, as a result of which government is losing revenue. Stone mining is going on, and that this duplicate carbon receipts are being issued in order to obviate payment of.
But kindly, my lord, kindly not divulge, my lord, I would pray.
Because the envelope that has been handed over, my lords, is a practice that has been deprecated by the Supreme Court in the Chidambaram judgment. It is I am entitled to a status report by them in the.
So your points, Mr. Dave, is this, that
Lords, by
first of all, based on seizure, this proceeding should not have been initiated,
Yes,
as you have stated.
Lordship.
As this point you have taken, and you are also you have complained of incorporation of section 111 of BNS.
Yes, ma'am. And all
The
others.
requirement under as stipulated under section 111(1) II is not fulfilled.
Lordship.
This is the third point, and you have relied upon paragraph 32 of Nevada judgment.
Yes.
Yes.
And my lord,
No further, please. Yes. Yes. I have heard. Yes. Mr. Mitro, anything you want to add?
Yes, see, the investigation is, my lord, at the beginning, my lord, that is being carried on.
Magnitude of the crime.
And my lord, your lordship has seen, my lord, the magnitude of the crime. Now, my lord, 111, my lord, it can be done, my lord. I can show your lordship, but
only thing that
yes,
where I am asking you, as Mr. Dave has taken this point, if you come to 111 and the definition as of
BNS. my lord.
continuing unlawful activity,
yes,
because if you consider, if you go through section 111 subsection 1,
yes,
any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offence, cybercrime, trafficking, so and so forth. Now this will constitute organized crime. Now while giving the definition which is offered under section 111(1) II, continuous unlawful activity means an activity prohibited by law which is a cognizable offence punishable with imprisonment.
yes,
Imprisonment of 3 years or more undertaken by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. So where is the fulfillment of these conditions? Taking note of the definition of continuing unlawful activity.
yes. Now, my lord, 2 charge sheets have been filed, my lord, and court has taken cognizance of it. Reporte bola bodhai ami jai na.
My lord, charge sheet has to be filed before invocation of 111, not after invocation of 111. That charge sheet is, I don't know what is being handed over, but if that is after 30th of July, then it doesn't fall within the ambit of 111, my lords.
167 charge.
Criminal divisional application being 3444 of 2026 is also heard today. Hearing of this revisional application is adjourned. This the matter for further consideration on Thursday,
কি দেখতো
27.
on Thursday next 27th August 2026 as 2 p.m. fixed matter.
I'm grateful, my lords.
Record minute that we have received a copy, my lord. They have served a copy of it.
nobody is denying.
Legal application.
Lord, my dear friend
Very
will
well.
trust me.
During course of hearing,
I think
add another line, during course of
My
hearing,
dear friend doesn't
copy of
trust
the
me.
revisional application is made over to the learned advocate representing state respondents.
Grateful.